So we proceed with basis of the law of obligations in the Russian Federation, and now we speak about non-contractual obligations. When we speak about non-contractual obligations, it is necessary to understand that here we do not have contract. So our relations are not regulated by the contract, but they are regulated by the law. It is Civil Code special chapter which is dedicated to non-contractual obligations. And we will speak about tort. Tort means obligations due to causing harm. Obligations due to causing harm. When we speak about tort, to identify tort, there must be four notions at the same time. First of all, it must be undue action or deed. What it means? It means that it does not need to be something illegal. It can be a negligent action. So, for example, you drink water from a glass bottle and you are on the 10th floor of the building and you decide, when you're finished with the bottle, just to throw the bottle out of the window. What it means? It means that you committed undue action. Undue action means that you should understand that later it is possible that you damage somebody or something, but you did not identify this at the moment you threw the bottle out of the window, though you had to identify this. Second, there must be fault present. When we speak about fault, so you threw the bottle out of the window, most likely it is negligence, so you did not think that you will damage somebody, but you should have thought about this. If we speak about intention, so intention, you intentionally threw the bottle out of the window. So, for example, your neighbor puts his Maybach near your window, and you, just because of social range, decide that you do not like Maybach, so you threw this bottle purposely. This is intention. What is important about fault? That fault, in case of tort, must be present. So if something is committed without fault, a person is not responsible. So, for example, you are shopping in a supermarket, and not intentionally, not negligently, just occasionally, you slip and you break the place where 50 bottles of cognac were placed. So there is damage to the shop, but there is no your fault. So in this case, you are not liable because it is not a case of tort. So next, what is necessary to be present? Real damages. So real damages. You threw the bottle, so Maybach is broken. Maybach is damaged. And damages are direct consequences of the deed. So there are problems with Maybach. Why? Because of your undue action, because you threw the bottle out of the window. So only in case all these four situations are present, we speak about tort. Of course, there are exclusions. So now let's speak about exclusions. When we speak about exclusions, in this case, not all four notions must be present, but only three. So we speak about activity with increased hazard to people around. For example, a driver is driving a car with a red light on, and a pedestrian passes a street with driver is driving a car with green light on, and the pedestrian passes the street with red light on. So driver with green light, pedestrian with red light. There is incident, there is collision. Whose fault is it? It is the fault of pedestrian, because pedestrian was crossing the road with red light on. But it is damage which will be compensated from driver, and driver will be responsible for this incident, because we speak about activity with increased hazard to people around. The same with a factory which committed damage to environment. The same with motor vehicles. So quite a lot of situations here. Next, result of illegal conviction and spread of information denigrating business reputation. So, what is omitted in this case? In this case, we do not have 4 situations, but we have 3 notions. We do not need fault here. Fault is of pedestrian. Liability is of driver. So driver is liable without fault. Moreover, in all these cases, it is possible to reimburse moral damage. Moral damage may be reimbursed only in cases provided by law. This is the case which is provided by law. What can be compensated? Quite a long calculations if person loses capacity to work, so earnings, expenses incurred, so to restore health, treatment, sanitary spa treatment, acquisition of special vehicles, for example, if a person becomes disabled person, and retraining. So what is resume? Resume is unfortunately that it is cheaper to kill a person than to damage a person. That is why in particular countries there are situations that they just kill persons who are damaged just to save money. And if a person is killed, still injury is redressed to other persons. These persons are dependents. So what it means? It means that if a dead person, if an injured person who is dead does not have any dependents, then no compensation is received. So minus up to 18 years of age, minus up to active legal capacity, students up to 23, which is funny. 18 is not included, 23 is included here. Women over 55 and men over 60, so the civil code has not changed, even that the pension age has changed. Disabled persons or one of family members who takes care of dependent persons. And who compensates liability? General case, liability is compensated by the person who has committed damage. But of course, there are exclusions. Exclusions means vicarious liability. Employer is liable for employee, so primary liability comes to employee. Later, employer, by way of recourse, may claim employee, but initially, the damaged person will call employer. So, for example, driver who works for a particular legal entity will answer for this driver. Later, yes, it may be compensated from driver itself, but primary liability on employer. Parents who are legal representatives for children up to 14 years of age. Insurance company. So insurance company concluded a contract with you, not with the person, to compensate, but it is vicarious liability. So liability passes to insurance company. And in case you bought some defective goods in a shop, you can claim a shop, or you can claim manufacturer with whom you do not have any relationship, but it is possible to claim manufacturer as well. But again, general case, liability is of the person who has committed tort. Thank you very much for attention.